Good afternoon, it's Cliff Potts. It is June 7th, 2011. Welcome. Almost rhymes. June 7th, 2011. Anyway, a few things we're going to talk about today. I am going to show you how to make cigarettes on a Tuppermatic. My landlady that I rent the room from also has one. Matter of fact, she's the one that turned me onto it. So I got some videos on how it works. Thought you liked that. I also have a celebration of being here 1 month now, back home, sweet home Chicago. And my friends made me a gluten-free cake. I'm also going to talk a bit about the Fourth Amendment and some of the other comments that were made on yesterday's videos. So, welcome aboard. Let's get going. The following was retrieved today from Wikipedia on the Fourth Amendment. Let me read through some important details for you. Now, the text of the Fourth Amendment to the Constitution reads as follows. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, in Mapp versus Ohio, 367 U.S. 643 in 1961, the Supreme Court ruled that the Fourth Amendment applies to the states by way of the Due Process Clause of the 14th Amendment. In Katz versus the United States, 389 U.S. 347 in 1967, the Supreme Court ruled that the amendment's protection do not apply when the searched party lacks a reasonable expectation of privacy. The Supreme Court also ruled that certain searches and seizures violate the Fourth Amendment even when a warrant was properly granted. In Katz versus the United States, 389 U.S. 347 in 1967, again, the Supreme Court ruled that a search occurs only when, one, a person expects privacy in the thing searched, and two, society believes that the expectation is reasonable. Now, affecting this is what's known as the Terry decision. Now, under Terry versus Ohio, 392 U.S. 1 in 1968, law enforcement officers are permitted to conduct a limited, warrantless search on a level of suspicion less than probable cause under certain circumstances. In Terry, the Supreme Court ruled that when a police officer witnesses unusual conduct that leads the officer to reasonably believe that criminal activity may be afoot, that the suspicious person has a weapon and that the person is presently dangerous to the officer or others, the officer may conduct a pat-down search or frisk to determine whether the person is carrying a weapon. To conduct a frisk, officers must be able to point to specific facts which, taken together with irrational influences from those facts, reasonably warrant their actions. So, there has been a great deal written about this, and I have just touched on the surface, as usual. A reasonable expectation, both from the person and society in general. Now, the problem we have in the United States today is I'm not too sure where society would expect a reasonable, where it would be reasonable to expect privacy. Now, we were talking about earlier the warrantless eavesdropping of phone calls. In a society, and this has already been ruled, that's part of the, excuse me here 1 second, that's part of the Matt versus Ohio case. If you are talking on a landline, hardwired telecommunications device, you can expect a certain amount of privacy. That's reasonable. Society in general considers that to be reasonable. However, does the same apply to a cell phone conversation, whether or not it's in a private residence? Now, you're going to have to answer that one for me. I would say no, and I'll tell you why. This comes from being a geek. The predecessor to the great-great-grandfather to today's cell phone is the field radio of World War II. That's not a telecommunications device equipped to be similar to a hardwired telephone. That is a radio. It is a glorified walkie-talkie. When they first started expanding in the public, we used to refer to them as the rich man's CB. They are digitized, but they are still radios. Actually, they're referred to as a transceiver because it transmits and receives. So, is there a reasonable expectation of privacy of a signal that is sent out over free air transmission, which can be snooped by just about anybody who has the right equipment and intercepted or listened to? It's not a lot different than your standard radio broadcast. With, let's say I'm listening to, and I'll use Chicago as an example, WGN. WGN transmits at specific power and a specific frequency, 980 on your AM dial. And correct me if I'm wrong, I'm doing that from memory. Anyway, thousands of people, maybe millions, listen to WGN. Not too much different with the cell phone, except is there expectation that only the other person on the other end is going to hear you? Now, with cell phones too, the other thing becomes pretty apparent. When you're having a conversation in public, everybody around you is part of that conversation. So, keep that in mind when using your cell phone. Is there a reasonable expectation of privacy in a cell phone conversation, especially one that's in public? I don't think so. I don't think it's reasonable to expect privacy at all. That's why those who are doing so do so at their own risk. Now, I'm not saying that in any of this that we haven't lost our right to expect privacy. Although in this day and age, I pretty much think we have. The expectation just simply isn't there anymore. But historically, let me go back to this. Historically, and unfortunately, I cannot give you the exact year that this occurred, but I'll give you some nutshells for you. It wasn't until the 1870s when the Bill of Rights, the first 10 amendments to the Constitution, were actually applied to actual cases in courts in the United States. That Bill of Rights was basically ignored up until after the Civil War. That's one thing to keep in mind. The other thing is the LA Police Department, well into the 1950s, post-World War II, had a propensity, if they thought somebody was a bad guy, just kicking in the door and doing what the damn well pleased. And they thought they were right in doing so. Unfortunately, I cannot cite the specifics of the given case, but what it boils down to is that the Supreme Court, once they finally got wind of it, were absolutely aghast as to how horribly the police department in LA was walking on the civil rights of the citizens of the city of LA. So, there you have it. That's the history. That's it in a nutshell. So, what's going on out there now? That's basically this. We already talked about the Due Process Clause, the 14th Amendment. We'll get back to that in another video. But in the realm of criminal justice, there's two approaches to dealing with crime. One is due process, which is a slow, methodical examination of facts pertaining to the individual case, allowing the judicial branch to deal with guilt or innocence. The other is called crime control, and that's where you shift from due process to allowing the police officers as a branch of the executive government to have a great deal more leeway in how they handle situations on the street that never will make it to the courts. This is what we're seeing in the United States today. This specifically started, it's been a creeping thing. I would say specifically started under Bush, but I'm not blaming him for that one. It probably started under the first Bush more than anybody else. But it's been a creeping thing along the lines because there's this mythology out there that too many criminals are getting away on technicalities. Well, first of all, flat out bullshit. There was a study done a number of years ago. How many? Late 90s. That showed that 1/10 of 1% of convicted criminals actually get out on technicalities. The other problem is that the technicalities that you're talking about, quite frankly, happen to be the law itself. That's not a technicality. That's the rules of society. So, you know, getting all up in arms about somebody who's supposedly guilty of a crime getting off on a technicality is bullshit. The prosecutors and the police officers did not do their job, and as such violated the law in the process. And somebody who has been convicted and overturned due to a technicality probably did not do the crime. So, okay, that is more than enough for today. That's Cliff Potts Civics 101 again, and thank you. Thank you very much.
Come on, baby, don't you wanna go? Y'all can help me say that. I don't give a damn. Come on, baby, don't you wanna go? Back to that same